to another episode of Arbitration Life. I am Janette Brin.
And I'm Hana Doumal.
London International Disputes Week is right around the corner, and the BVI International Arbitration Center is a proud institutional supporter. The conference's theme this year is Dispute Resolution, Global, Sustainable, Ethical. The conference will run from May 9th to the 13th and provides an opportunity for dispute resolution professionals from around the world to debate the current disputes landscape and the future of disputes resolution. Hana, you'll be representing the BVI IAC at London International Disputes Week. Are you looking forward?
Yes, absolutely, Janette. I'm very excited to be able to meet in-person practitioners from around the world, attend thought leadership sessions, and reconnect with friends of the BVI IAC. The conference program features a range of speakers debating issues that span the dispute resolution landscape.
So our guest today is no stranger to London, having been based there for a number of years. She has been called a superlative, a star, an excellent lawyer, a superb team player who puts her clients first at all times. She is co-head of International Arbitration at CMS, Cameron, McKenna, Nabarro, Olswang, LLP, that was a mouthful, a role covering the UK, Central and Eastern Europe, the UAE, Singapore, Turkey, Russia, China, Brazil, and Mexico.
Specializing in both international commercial arbitration and investor-state disputes, she represents clients in arbitrations under the rules of major arbitral institutions and the UNCITRAL rules. She's dual qualified in England and Wales and in the US, Texas, and Washington, D.C. She's a solicitor advocate of the higher courts of England and Wales, and she works in both English and Spanish. She also advises clients on investment, restructuring, and on strategies, options, and tactics for minimizing the prospects of full-blown disputes. She has particular experience in energy, oil and gas, mining, and other large-scale project disputes in Africa, the Middle East, Central Asia, the Indian subcontinent, and Latin America. And she has represented many of the leading global energy and construction companies. Please welcome Sarah Vasani. Hi, Sarah. Welcome to Arbitration Live.
Thank you so much. It's great to be here.
How are you? How are things in London?
Things in London for the first time in a long time are sunny and warm, so I can't complain. It's been a lovely bank holiday weekend here, and things are quite nice.
That's good. Well, I'm looking forward to coming to London soon for London International Disputes Week.
Nice,
Yeah.
Nice. Well, Sarah, I'm going to go ahead and get us started. Can you tell us about your role as co-head of International Arbitration at CMS and what you enjoy the most about it?
Sure. So it's a relatively new role, as I just joined CMS in September of last year. My role covers the United Kingdom, Central and Eastern Europe, the UAE, Singapore, Turkey, China, Brazil, and Mexico. So it's quite a large geographical spread. And although I'm co-head of the group along with Richard Bamforth, and this is a leadership role, CMS is very much about the team. So all of our partners, associates, and staff very much work together, to ensure that we give our clients a seamless experience across all of our offices and across all of our areas of expertise. I think the things that I like most about my role and really what drew me to the firm are three things: the people. So it's fantastic culture, very big on diversity and inclusion, broad geographical spread. So there's wonderful people from all over the world, which I think is always very helpful when you're trying to learn the ins and outs of different jurisdictions. The global reach. So as I just mentioned, those jurisdictions, but we have within the CMS network even a further geographical reach. So we typically can help our clients wherever they might be. And then finally, there's a real specific sector expertise in banking and energy. And so one example is the energy and climate change group. I mean, if you need to find the person who does lithium batteries, or the person who has, an expertise in a particular wind turbine metal, we've got them. So it's a nice cross between geographic diversity, sector expertise, and then the people are really, really wonderful. It's not uncommon to find people who have been here 25 years, which says, I think, a lot about law firms, because most people don't make it that long anymore.
Well, that's awesome. Sounds like a really fun place, and like you're always learning with so many.
It is an awesome place, and we certainly are always learning, and learning a great deal from our colleagues in the other offices, and we speak quite frequently, so it's great.
Great.
That's great. Now, Sarah, did you always knew you wanted to work in international arbitration?
I knew fairly early on in my legal career. So I studied in the US. I was at Vanderbilt for law school. And during my summer associate stints in Texas, actually, I had studied international relations. So I knew I wanted to do something with international relations. I knew I wanted to do something global. And then I actually met what is currently my husband on a job interview in Texas. And he did international arbitration. So he was telling me about the cases that he was doing in Brazil, and how it seemed like this perfect mix between politics and international relationships and international relations and law. And so for me, I knew I wanted to do something contentious. I knew I wanted to do something international. So that was the perfect marriage of the two. And really, when I started my career at King & Spalding a long time ago in Houston, Texas, that's when King & Spalding was doing a lot of the Argentinian cases that came out of the pacification crisis back in 2002. So I was doing a lot of those cases. So for me, again, it was a lot of ICSA cases. So the perfect opportunity to have that marriage between politics, the law, and then of course language skills, which I also found very rewarding to use. So it started on a job interview. I was keen to do that before I started my practice, and then I started immediately doing those ISDS cases with King & Spalding in Houston.
Wow, that's wonderful.
All right, so I feel your passion for international arbitration already. What would you say makes an arbitrator a good one?
Great question. So I think it goes without saying that anyone who's sitting as an arbitrator should have the necessary skill set to decide the case that's before them. So they should have the necessary skill set in terms of the governing law, and they should be able to apply the facts of the case and do that efficiently. What I think, though, and I think what we know, the biggest issue for most parties comes down to the time and costs associated with arbitration. And we see that over and over again on all of the Queen Mary studies. Whenever they do it, it's the number one concern. How much is this going to cost? How long is it going to take? And I think there's a real systemic problem that we have too many of the same arbitrators, too few arbitrators doing too many of the cases. And so what that leads to is a lot of delay, increased costs, and oftentimes splitting of the baby. So I think what the parties are crying out for, and certainly that's what my clients desire when they seek to resolve their disputes through arbitration, is a really efficient and cost-effective manner of resolving their disputes and getting certainty and getting finality. So back to your question of what makes an arbitrator a good one, I would say preparation, efficiency, and leadership. So part of that comes with being part of the, having the energy that I think the new generation of practitioners have that are now sitting as arbitrator, my contemporaries who are kind of younger, more diverse, and very much hungry for that work. So I think those younger arbitrators are showing a tremendous amount of preparation, being very efficient, responsive to the parties. So as soon as the parties are emailing, they're getting back immediately. And they're also taking lead of those cases. So, they're suggesting things to parties about how to run the dispute more cost effectively. If it's a relatively small dispute, is there really a need, for example, to have document production? Do we really need to have a large witness hearing when most of the issues can be dealt with on the documentary evidence that's before it? I also think it's really important to have parties involved in the arbitrations. I know as counsel, I always encourage my clients to come to the first procedural hearing. I think there's a big difference in how counsel might act when their client is there and they need to open their calendars, and when the client is not there and they need to open their calendars. So I think by promoting those elements that promote time and cost efficiencies, you can really get a great result for the clients and leave the clients with a satisfied result at the end of the day. So I very much encourage party and client participation. That's what this process is here for. And then I do think you need to take leadership of the cases that you're serving as arbitrator, suggest some methods of ensuring that the arbitration is run efficiently and cost effectively, and just be all over the details so that the parties can be confident that you've read everything, that you've come prepared, that you're ready to resolve the dispute, and then issue an award quickly after the hearing. Your memory won't get better the longer you wait. So I think it's important to get that award out as quickly as possible. And I think win or lose, the parties appreciate that, because at the end of the day, they want certainty and they want finality. So I would say those things: preparation, efficiency, and leadership.
Yeah, all good points.
Thank you, Sarah. And now, so you're a member of the steering committee for the pledge on greener arbitrations. Could you please tell us a bit more about the role of that committee?
Sure. So the campaign for Greener Arbitrations, which is spearheaded by the fabulous Lucy Greenwood, who has really first established the pledge, and then she established the Green Arbitration Committee. And it's really comprised of a lot of different members of the arbitration community, from law firms, institutions, legal services companies, and all of us who are involved want to focus on how to continually improve the international arbitration process, but also how to do it in a more environmentally friendly way. Lucy will tell you of the times she spent. She also started in Houston when she got done with a hearing and saw those, bundles upon bundles of documents that were never opened during the course of the hearing. And then she investigated into how many rainforest or how many trees we were killing with each arbitration hearing, and essentially came up with a group and protocols that serve as practical guidance for law firms, for arbitral institutions, for different legal services providers, for arbitrators, a green protocol, PO1. And what she's done is all those individual subcommittees have worked on those practical guidelines that can be implemented from the get-go in daily life. And that leads to, questioning whether or not we need to have international travel when we do. I know that if there's one good thing about COVID, I think we've all found that simple hearings, and by that I mean procedural hearings and hearings on legal issues, can often be done just as a lot more cost effectively by virtual hearings, right? So we can really think about, when do we really need to travel? When do we really need to be in in-person hearings? And when can we do things virtually? When can we have all of our documents online? It's often more cost effective to give a tribunal member an iPad with all of the documents contained on it than it is to print all of those documents out and, of course, kill the number of trees that are required to do so. So I think COVID has really allowed us to become more comfortable working virtually, working with online documents, and the campaign for green arbitration really just gets, no matter what area you are in arbitration, if you're an institution, if you're a law firm, if you're an arbitrator, it gives you suggestions, concrete, practical steps that you can take and put in place immediately, so that you're causing less of a carbon imprint and impact.
Thank you
Footprint
so much.
is what I meant to say. So
Yeah.
that you're causing
You're
reducing your carbon footprint. Exactly.
That makes sense. Thank you.
Yes. What would you say is your greatest achievement in your career so far?
Ooh, that's a tough one. I think the greatest achievement would be one particular case that I did when I had just left my first firm, King & Spalding, and I had headed up the international investor state dispute resolution practice of my previous firm. The first case that I did was for a Malaysian investor, a Thai investor in Malaysia. And that family, the Bunyanet family, had spent about 20 years fighting their case before the Malaysian courts unsuccessfully. And essentially, this was this really sweet old woman and her family who had land, beachfront property in Malaysia. They had been defrauded of that land in a decision that was universally condemned, even by the Supreme Court of Malaysia after the fact. But the fact was that they had exhausted their local remedies. There was really no other resort other than for a bilateral investment treaty claim. And in this case, it was a claim under the ASEAN Treaty. And what was really rewarding about that case is it was an individual family. They'd been fighting this battle. They had a Facebook page dedicated to it. It was a very sweet family business, good people who, had been faced with this injustice, and there was really no other way to get access to justice but through this investor state claim. At that time, I think as fate would have it, a lot of these times, it's in part the luck of the draw and what's happening in the political sphere at any particular time in the case. But there had been a new election in Malaysia. There was a new regime that came into power that was very much cutting back on corruption and wanting to do the right thing. And we pursued settlement negotiations with the government of Malaysia. And in a very short period of time, we were able to reach a settlement agreement for the Bunyanet family, which was excellent. They were elated, and seeing them go from, day one, where they were so frustrated, they'd spent 20 years fighting this case and didn't think they had any other means to access justice. And then to, fast forward 8 months later, they had a huge check in their hand and were able to settle in a way that was favorable to them. It was also, I think, favorable to the state in the sense that it would have been much more expensive had they gone through the long years of fighting it in legal proceedings. But it really showed me two things. One, you can have a huge impact on the individual lives of your clients, which is something I always, really take pride in, and it's really the reason I do what I do. And then second, investor state dispute settlement can work, and it does work. I had thought previously, states will never settle. What's the point? There's very unlikely to do so. But actually, we gave it a try, and we gave them a lot of information, and there was a great exchange between the state and the investor, and both parties reached a settlement agreement, which saved a lot of. When we look at the costs of arbitration, right, they're between 5 and 6 million. Depending on whether you're the state or you're the investor, that was a huge amount of savings, right? So we were able to get a resolution quickly that was favorable both for the investor, but also for the state. And that gave me belief actually that these things can work. So that was, I think, very, very fulfilling.
Sounds like a beautiful story.
Yeah.
Awesome.
Yeah, definitely. And thank you for mentioning more settlements, because this is definitely not what arbitration lawyers talk about, but it's very important to be able to.
Yeah, and they should. I mean, I think key to knowing your client and servicing your client is finding out what they want. And if they want a settlement, I mean, lawyers, I know sometimes the incentives are not there to try to settle the case, but I think you will get a reputation and you will get repeat business if you really put your client's interests first and try to get the result that they want. And a lot of commercial parties, not just in investor state cases, but perhaps even more in commercial arbitrations, a lot of times people just want to get on with their business. They want to, cut their losses, get a fair result for both sides, and work through it in a business commercial way. So I think lawyers should always be talking, that's first and foremost, discussing what is your client's goal, what do they want to achieve. If that's settlement, then you help them get that as quickly and painlessly as you can.
Yeah, absolutely. Now, Sarah, can you please share with us an experience that has been most impactful in your career?
Okay, most impactful. I would say there was a case that I did. It was an LCIA arbitration when I was kind of a mid-level associate. And it was, again, one of those cases that dealt with family businesses, two very invested businesses. One was based in Mexico. Another party was based in Greece. and they had a very contentious dispute that went beyond the scope of anything either the clients or us as counsel could have imagined. And essentially, in retaliation for this commercial arbitration that was ongoing in London, the other party instituted criminal proceedings in Mexico for copyright violations. And I had, which was potentially one of the nicest clients in the world, just again, family business, very, very nice people. And their offices were raided one day by men masked in machine guns who took my client and 6 other employees to prison in Mexico right before Semana Santa, when everything closes. So basically, in that system, the criminal system in Mexico, you have a very short period to prove your innocence, or you will be stuck in jail for about a year. And my client at that time had just learned that his wife was pregnant with their first child. She was actually on the way to the offices when she saw this raiding happening, and one of my client's brothers captured this on his cell phone. So what I essentially did was I got everything apostolized relating to the arbitration, because in Mexico, the criminal proceedings, they wouldn't accept emails because they can be tampered with. Got everything apostolized, flew to Mexico, went to Mexican criminal court and testified in Spanish using my Spanish skills about the impetus for this proceeding and how really this was being used as a means of cutting off the lifeline of my client's business, which was impounded because of these proceedings, but also as a means of trying to force us to back down from the LCIA arbitration. And we explained to the judge in the criminal proceedings that this should really be before the arbitrator that was constituted and ongoing in London. And so we were able to, at the same time, issue preliminary measures in the LCIA arbitration, and then to get our clients out of jail. So we were successful, and that was the most important thing, of getting him and all of the employees out of prison in a very short period of time, and then also writing a very compelling provisional measures application, which allowed us to get relief from the arbitrator in London and get everything moved back to the commercial proceedings. So that was very rewarding, because it really was a matter of, it was a scary situation for our client, and especially one of the female employees who was in a prison that has a horrible record for committing atrocities. So we were able to get everybody out safely in a very fast manner. And I never thought I would be testifying in criminal court in Mexico, but there you go. It was quite an experience, and really a great effort that allowed us to get our client the best possible result we could.
Wow, thank you so much for sharing. What an experience.
Wow.
It was interesting. It was an amazing case, and wonderful people and clients, and it was really rewarding, because they were also so strong to be able to go through that. Yeah. I felt quite bad that this arbitration had resulted and led to the other party using these tactics, but that often happens, right? That often happens as a means of achieving settlement or getting an upper hand. A lot of times an opponent will take measures that you would hope they wouldn't, but we were able to resolve that fairly quickly and get our client out of jail, and then proceeded to be very successful in the arbitration. So in the end, very rewarding. I'm not sure if that client would use arbitration though in the future, in light of the ordeal that they had to go through to get the result.
Wow. Well, congratulations for that. Like, seriously.
Thank you.
Wonderful.
All right. So can you share with us a pearl of wisdom, a wise word or saying that you have treasured throughout your life?
Okay, so when I think about wise words of wisdom, I think about Michael Jordan. I grew up watching Michael Jordan play. I was from Michigan originally. Used to watch the Detroit Pistons. We're very big rivals of the Bulls. Dennis Rodman played for both of them for a while. There's a great show on Netflix about Jordan, actually. But one of his sayings was that, talent wins games, but teamwork wins championships. And I think that's very true in arbitration. I think when you're building a team or you're leading a group, it's really important to have team members that have all different skill sets, that are from diverse backgrounds and have different contributions to add to the team. I think it's really important to have all of your lawyers on the team and staff speak up if they have ideas. You know, a lot of times when we have arbitration teams, we have people from different jurisdictions, so from civil law jurisdictions and common law jurisdictions, and they might approach problems differently, and they might have great ideas that because of our legal training, we might not all see the same ideas. So I'm very much a proponent of having the team work together. I find different people have different skill sets and different strengths. So, you know, you'll have your train conductors who are methodical at running, you know, cases and making sure everybody's on time. You'll have amazing drafters. You'll have great researchers. You have better strategists. So it's about putting together a team that really works well together to achieve your client's interests. I think the other, maybe if I can I give two pearls of wisdom? This is a bit unrelated to that one, but it's, you know, there's a saying that, you know, a flower doesn't compare itself to other flowers, it just blooms. And I think it's also important in our careers, we take different career paths, and often it's very tempting to say, well, this person started when I started, I should be here or I should be there, and I should be comparing myself to them. And when you look at LinkedIn or you look at different you know, accolades that others might be getting of your same generation, you might think, well, I'm behind the curve. But what you're seeing, you know, is someone else's highlights, and you're comparing that to your own behind the scenes struggles, right? And so you're seeing the results of everyone's work, but really, you know, we will all get there at different times. We don't all take the same path. We don't all get there the same way, but it's just important to focus on yourself, what you want to achieve in your own career, and you'll get there eventually. So don't constantly compare yourself to others. Just you, do your own path and achieve success that way.
Awesome. Yeah, Sarah, did I tell you that you are awesome? You just dropped so many gems now.
You just did. It's
Well,
terrific.
I think you're awesome as well. So thank you so much.
This is great. Yeah.
And now, Sarah, in your opinion, what would be 3 words that describe what you do?
What I do. So, well, what I do, I think, is similar to what a lot of lawyers do. So maybe what I'll tell you is how I do it. That might be a bit different.
Okay.
3 words, I would say: fierce, committed, and empathetic. So fierce, you know, there's 2 times when I have my game face on. And that is when I enter a hearing room and I'm about to, you know, advocate on my client's behalf. I will walk through brick walls for my clients. I will get the results. And I always call my cases my babies. So if you mess with my clients or if you mess with my children, I have 3, 12, 9, and 4. I will be a tiger mama, and I will do what needs to be done. So fierce in that context, right? I fight for my clients. I fight for my kids. Committed. You know, it's my nature to dig a little bit deeper and to work a little bit harder. And part of that is, you know, I grew up at a dairy farm in Michigan. So, you know, before school, you had chores, and after school, you had chores. And I've watched my father and everyone in my family really always work hard. You can't really take a day off because the cows need to be milked 3 times a day. So you're always working hard. And I think that principle of being committed and working hard, I've always employed that to my clients' benefit. So I think it's important to be committed. And then finally, I think in addition to being fierce, I think it's important to be empathetic. Because if you don't understand how others around you are feeling, and if you're not able to lead them in a way that they will be committed to the same cause long term. So I find you get a lot more out of your associates if you know, really are committed to them, you're empathetic, you understand what they're going through. We're all human beings, and I think it's really important to be human and to let them know that you are human, and clients as well. I find that clients really are attracted by the person that they're working with. It's not necessarily the law firm or the name. It's, you know, they want you to understand their problems and to give them solutions. And so I think being empathetic to what they're going through is key to that, as it is to lead a great team that gets the best results. So I think those would be the 3 key words I would use.
Thank you so much. Those are great words. And I had the chance to see you at hearings, actually. Years ago.
That's right. I saw you once quite a long time ago in a hearing involving Ecuador. That's right.
Yeah.
That's when I was young.
Oh, come on, you're still young. What are you talking
That
about?
was a long time ago.
Oh, gosh. Well, we're just about to conclude our interview, but we can't let you go without asking. I mean, you've left us with so much to stop.
Yeah.
I have to ask, what is the theme song that gets you through the day?
Oh my gosh, my theme song. You know, it's funny because I'm thinking of my 4-year-old son has taken up the song "I'm a Survivor, I'm gonna make it, I'm gonna work harder, I'm gonna be stronger." So he has been singing that song thanks to his big sisters every single day. So that's what is currently in my mind. But I think that's that one. There's also another one about a boss lady, but I think it has a profanity, so I don't know if I can say it. Do you guys know which one I'm talking about?
I think
I'm a boss and I shine like gloss.
Yeah. Okay.
That's the other one I think of, just to get some motivation going.
Yeah. Well, thank you so much, Sarah. It has been a pleasure. I look forward
You
to
as well. Thank you so much. And I can't wait to see you guys in London for London International Disputes Week.
Yes.
Absolutely. Thank you so much, Sarah.
Thanks a lot. Have a great evening, ladies, and we'll speak soon.
Absolutely. Bye-bye.
All right. Take care. Okay. Bye-bye.
Thank you so much, Sarah, for joining us today on Arbitration Live.
For more Arbitration Live, please be sure to hit the subscribe button. Plus, follow us on LinkedIn, Twitter, Instagram, and Facebook at Arbitration Live.